Picture this. You're raising capital for your startup, real estate syndicate, or investment fund in Florida. You've got a group of eager investors lined up. A friend tells you, not to worry, just call it a private placement and you'll be exempt from SEC rules. Now fast forward 6 months later, your bank account is frozen, your investors are panicking, and you've just received a subpoena from the Securities and Exchange Commission. You ask yourself, what went wrong? I'm Santiago Cueto, a board-certified international business lawyer and best-selling author based right here in Miami. For nearly 30 years, I've helped Florida companies raise millions of dollars through private offerings, and I've seen what happens when they mistakenly believe exempt means invisible. Today, I want to expose the myths around private placement and reveal why SEC scrutiny is alive and well, even the so-called exempt offerings, especially right here in Florida. Florida is ground zero for private capital. From real estate syndicates in Brickell to tech startups in Wynwood, private offerings are booming. But this surge has caught the attention of the SEC, the Florida Office of Financial Regulation, and even whistleblowers. Private placement exemptions aren't get-out-of-jail-free cards. They're complex, conditional, and require strict compliance. Here's power move number 1. Reg D does not equal a free pass. Most private offerings rely on Regulation D, but just because they are exempt from registration doesn't mean you're exempt from regulation. You're still subject to anti-fraud rules, state notice filings, disclosure obligations, and limitations on solicitation. If you mess up any of these, even unintentionally, you've just handed the SEC a reason to investigate. Here's power move number 2. Under the SEC rules, you can't advertise or solicit publicly, but you can include up to 35 sophisticated, non-credited investors. Sounds great, right? But here's the catch. The burden is on you to prove they're sophisticated, and if they suffer a loss, guess who they'll blame? They're gonna blame you. Under the SEC rules, you can advertise, but only to verified, accredited investors, and no checking a box at a website isn't enough. You must take reasonable steps to verify, like reviewing tax returns or having a third-party accountant or attorney confirm their status. Here's power move number 3. State compliance still applies. Florida has what's known as blue sky laws. Even if your offering is federally exempt, you're still required to file Form D with the SEC and notice filings with the Florida Office of Financial Regulation. Miss those filings and you're technically operating an illegal offering, and regulators are watching. Florida's history with Ponzi schemes, boiler rooms, and crypto fraud has made it one of the most closely monitored states for securities violations. Here's power move number 4. Fraud is still fraud. Exempt offerings are not exempt from anti-fraud provisions. Whether you're pitching investors with slick decks, future projections, or Instagram reels, any misrepresentation, omission, or exaggeration can trigger enforcement. The SEC has made it clear. If you mislead investors, you'll be held accountable, even if the offering was, quote, exempt. And it doesn't take much. A projection that wasn't backed by reasonable assumptions, a business model you knew was flawed, a risk you failed to disclose, that's all it takes. Here's power move number 5. Document everything. If you want to survive an audit or lawsuit, your paper trail must be bulletproof. That includes subscription agreements, accredited investor verifications, private placement memorandums, disclosures of risks, and investor questionnaires. And if you don't know what half of those are, you shouldn't be raising capital without legal counsel. The word private sounds safe, yes. It sounds exclusive, but in the eyes of the SEC, it means you have more responsibility, not less. If you're raising capital in Florida, you must treat every offering like it's under a microscope, because it is. The SEC doesn't knock first, they subpoena. I'm Santiago Cueto. If you're thinking about launching a private placement, or you've already raised funds and you're unsure about compliance, now's the time to take a second look. Don't wait for a regulator to do it for you. If you found this helpful, like, subscribe, and comment below. I would love to hear what's been on your biggest challenge navigating private placements. Because when it comes to securities laws, what you don't know can cost you everything.